Good afternoon, everybody. I'm Fiona DiDomenico, Regional President with the Castle Group. Thank you so much for joining us this afternoon. We have got a couple of great industry experts on the webinar with us today, and we're going to have some great discussion. So thank you for joining. Wanted to take just a quick minute and tell you a little bit about Castle Group for those of you that don't know. Castle Group is a locally owned Florida-based firm. We are all across the state of Florida and also in Texas. And we kind of specialize in associations, excuse me, associations that have teens on site. A lot of our communities are highly amenitized, so they would have full food and beverage. We have lifestyle divisions, lots of big, beautiful amenities. And we would love to help you out and answer any questions that are not covered on today's webinar. Feel free to reach out. At the end, we will have a slide up, and you can reach out to us at info@castlegroup.com. So thanks for joining. And I wanted to now introduce our panelists. We have Alan Tannenbaum, Brian Street, and Joe Thompson. So gentlemen, thanks for joining. And Alan, I'm going to turn it over to you. If you could kind of introduce yourself and tell us a little bit about your company.
Alan Tannenbaum with Tannenbaum, Scroll, and Mull and Kleinberg. Our main office is in Sarasota, but we have offices in Fort Myers, St. Pete, Clearwater, and Orlando also. We're construction lawyers. A lot of our work is done in the community association field. We do construction defect cases. We handle condo and homeowner turnover and turnover claims. We also do a lot of repair project consulting. So we help prepare construction contracts. We advise groups on best practices in approaching construction projects. And on repair projects that don't go well, we get a lot of calls on those too. So that's what we do.
Excellent. Well, welcome, Alan. Thanks for being here. We're excited to learn from you today. And next we have Brian Street. Brian, welcome.
Thank you, Fee. Good afternoon, everybody. My name is Brian Street. I'm with M2E Consulting Engineers. We're a multidisciplined engineering firm with offices in Miami, West Palm, Orlando, and expanding to the west coast of Florida. And basically, we focus, similar to Alan's on the litigation side, we focus on the construction defects, forensic engineering. So if there is an issue within a building, either from construction turnover through, after 40 years, we're able to dissect what that issue is. If you have water intrusion, concrete spalling, things of that nature. We are multidisciplined, so we have both structural, mechanical, electrical, plumbing. So we can really take a look at the entire building envelope to all the equipment systems within the structure to ensure that we can go from the repair to a nice finished product. We also act if something doesn't go right. We actually act as expert witnesses as well. So we have experts in all fields, all licensed PEs to help in whatever case may arise. So thanks for having me and looking forward to a great discussion.
Excellent. Thanks, Brian. And last but not least, Joe, welcome.
Thank you, Fiona. Joe Thompson here with Gulf Shore Insurance. I'm a client advisor and partner with Gulf Shore. If you're not familiar with our firm, for those of you that are listening, we've been around for 50 years. We were founded in 1970. We have an office headquartered in Naples, also an office in Fort Lauderdale, Marco Island, Fort Myers, and in Sarasota. One of our areas of specialization as a full-service insurance agency is community associations. So we handle the risk management and insurance for about 800 associations from the Tampa area all the way down to Marco Island and over in the Tri-County area as well. And that's an area that I work in exclusively. Majority of my clients are coastal condominium associations. I handle clients from essentially Tampa area south to Collier County. That's basically the area that I work in exclusively. And a couple of years ago, with regard to Gulf Shore, we did partner with one of the largest brokers in the world, private insurance brokers, a company called Acrisure. So we are still Gulf Shore Insurance, but we are an Acrisure agency partner now as well. So thanks for having me today. And Fiona, I'll kick it back over to you.
Excellent. Thanks, gentlemen. So Shauna, if you could go to the next slide for us, we'll try to give everybody a little bit of an idea of our discussion topics for today. And I think what we'll do, if it's okay with you guys, is we'll just kind of start right at the top. one of the first topics we had is what is an association's obligation under Florida statutes or their declaration regarding maintenance and repairs? So that's kind of a big topic. Alan, maybe do you want to start us off?
Yes, I'll talk about condos and HOAs because it's a little different.
Yes.
In the Florida Condominium Act, there's a specific statutory section that obliges a condo association to maintain and repair the property. It's not a discretionary issue. It's the same thing as requiring associations to buy insurance and do budgets and hold meetings. They're all mandatory requirements, and in the Condominium Act, it's a specific obligation the association must do relative to the common elements. It's coupled with a provision of the statute which says that a condominium owner cannot act on behalf of the association, which means there's no self-help. So if a roof is leaking, it's a common element roof and a unit's getting damaged, that owner in the unit that's getting damaged can't call a roofer to go fix the roof. They're totally dependent on the association to take action. For homeowners associations, and what you'd be talking about is association-owned property, like the clubhouse, the swimming pool, the roadways, and so forth. But some homeowners associations also have multi-family buildings, so 4plexes, 6plexes, 8plexes, that they have maintenance and repair responsibility on. And for homeowners associations, the obligation to repair comes from the covenants and restrictions. And for condos also, the repair requirement does come from the declaration of condominium also. So condos, it's a statutory requirement along with the documents. For homeowners associations, the authority and the obligation comes from the documents.
Okay, excellent. So that gives us a good kind of overview, I think, of, responsibilities. And a question we often get, and what we're going to talk about today, is how does delaying a repair affect an association? And what are the risks and liabilities? And I know we were chatting a little bit before we started today about, what the danger might be of having, an engineering report done. An association does an engineering study and then basically lets it sit and doesn't do anything with it. I'm interested to hear feedback from the three of you gentlemen on how that, it may not be a great thing to do.
Well,
Yeah.
I'll chime in first as the engineer. Let me say first that delaying a repair can negatively impact an association in a dramatic way. You should know that concrete and rebar, if they're damaged, they can't repair themselves. So they have to be repaired. And if it causes some structural integrity issues because the concrete is falling off the building or the rebar is rusting, it's no longer doing what it was designed to do. So delaying that repair when you start to notice cracks in the stucco, which could symbolize, water intrusion, and especially for a lot of our buildings that are, on the coast, on either coast, when you have a lot of that salt water intrusion into the buildings, it can cause a lot of damage, some of it not necessarily seen. So we're big proponents in when you start noticing cracks in the stucco, when you start noticing issues with some of your mechanical equipment, to hire an engineer to come out and inspect. Sometimes cracks in stucco can be superficial and they will be covered up by paint. Other times cracks are symbolic of a much larger issue going on within the building. If you have a roof leak, as we discussed earlier, it may not be necessarily visible from when walking around on the roof, but you're starting to see the water intrusion getting underneath the roof, and that can cause a lot of damage for that building. So it's always good to hire a great engineer to come out and really do an overall kind of property condition assessment to look at all the mechanical equipment and a licensed engineer, by the way, a licensed PE in those major disciplines, not a kind of a one-stop shop engineer. I'm a civil by trade, so I wouldn't opine on electrical. So you want to make sure that you have a true PE in that discipline to come out and take a look at all the areas, the building envelope, your mechanical equipment, and provide a report that you as the board can take and strategically plan on how those items are going to get fixed.
Yeah, it's a great point, Brian. From a management standpoint, whether the folks on the webinar today, some are probably self-managed, some are probably with management companies, regardless of how you're operating the association, you want to make sure that you've got a regular inspection process for all of your areas, so that over time you're checking in and you're looking at these things so that you can start to see as things may be changing and deteriorating, especially with water intrusion. I think there's a saying, what you can't see can hurt you, right, in this industry. So doing regular inspections of the property and the mechanical items is very, very important, and documenting that so you've got something to refer back to. Alan, you looked like you wanted to say something there.
Always. And I think I can set Joe up for some comments on this issue too. So in both the Condo Act and the HOA Act, 718 and 720, there are statutory sections that say if the association does not fulfill its obligations either under the documents or under the statute to repair, an owner has a few choices, couple of choices. One, they could seek an injunction in court to require that the repair be undertaken, and they can get damages. So the Coronado case, which was decided many years ago, was a plumbing backup. A unit owner was getting sewage in their unit. It was a common element problem. The board wasn't taking action. The owner actually had to leave the unit. It got so bad. They sued the association. They got an injunction requiring the repair. They got damages, significant damages for health impact as well as interior unit damage. They got their attorney's fees and they got their court costs. There's also an HOA case that applied the same concept for a drainage problem that caused damage to a lot and into a home. So there is a penalty with the statute that owner could take advantage of. The other problem, there is a court decision that says that if you allow a condo building to deteriorate, it can constitute a material alteration. The deterioration of the building itself materially alters the structure, and you can't do that in a condo unless you have a vote of the owners. And so there's a court decision that says that it's also a material alteration that an owner, so it's another option that an owner has. I think what Joe can talk to is how it's going to affect insurability as a risk of the association if it's not repairing items, or if a claim is filed, what might be the repercussions?
Well, there's a lot of variables at play with it. Obviously multifaceted when you're dealing with, existing damage. Property carriers have a tendency to have an existing damage exclusion embedded in their policy. So in the context of an example, say you've let something deteriorate, or you've had a prior peril, maybe a storm, and there was some damage that nobody ever addressed. Well, moving forward, if you file that claim, they're going to send out a field adjuster, and they're going to know right away that there was prior damage, and they're going to deny the claim. So that's obviously a huge problem in that situation. And we saw that happen, with Irma and subsequent claims that happened thereafter, where a lot of carriers were embedding these exclusions in the policy for existing damage. So you have to be cognizant of that. The other thing too, with anything related to the building envelope, whether it's the seals around the windows or roof repairs that are necessary related to water intrusion, you have to think about it as a board. if you kick the can down the road, you're taking a huge risk. Number one, if you have an engineering report on file, you've already gone through the motions. That's all documented. So if something were to happen, you're basically negligent, because you've got this already, knowing that you're being told by a professional you need to make the repair. And secondarily, if you don't understand what your coverages are actually going to cover you for from a property standpoint, say your seals are faulty in your windows. If the wind blows and we have a hurricane, you're getting sustained winds of over 100 miles an hour, you're going to have a massive amount of a peril called wind-driven rain. So if you don't have coverage for that, that's another massive issue you're going to have to deal with from a self-insurance standpoint. So there's different variables there. We see it a lot too with cast iron pipes. I have a lot of clients that have cast iron, and those are a huge nightmare. And I'm sure the folks listening that have dealt with that understand it in detail. But they leak, obviously. It's a big problem. And some folks, they nip it in the bud. They take care of it. They put a big project in place. It could be millions of dollars. It may be over the course of a few years. Others kind of do piecemeal repairs. And that's always a problem as well, because now carriers are coming back and they're providing huge water damage deductibles on the renewals for these types of properties, and some of which they're actually eliminating water damage altogether. So if that happens, you're an association that has not fixed your cast iron pipes or leaky pipes or whatever the circumstance might be, you may find yourself in a situation where you could get general liability, but guess what? There's no coverage for water damage. How is that a problem? Well, guess what? If the HO6 carrier, in the context of a condo, subrogates against the association for negligence, you're self-insuring it. So these are just not worth the risks, and you obviously need to consult with an engineering firm and make the repairs, and whatever finances you need to do, relative to making that happen. That's something the boards are going to have to decide, but it is very important to initiate and implement once you know what needs to be fixed.
And Joe, that's a great point. Sorry, Fiona, to interject, but you brought up, the cast iron pipes, for example, where a lot of associations have put a Band-Aid on a certain area. They have a leak in a small area, but they don't extrapolate the issue to the entire association. And from our experience, the accumulation of those Band-Aids costs way more than just the project from if you just had an engineer come out, take a look, come up with a proper repair protocol and the construction. So it may look like a huge upfront cost when you take all that, but if you add up all the Band-Aid fixes over the years, it costs way more.
Absolutely agree.
Yeah, those are great points. And I think that speaks to the benefit of, again, pulling the team of experts together for your particular community. Get your property manager, get your engineer, get your committee if you've got, a maintenance committee or whoever it might be, involve the association's, attorney and insurance, and get everybody on the same page as to, what's going on with this particular, major project. One of the questions that we have is, how does an association go about implementing a special assessment? And I can tell you, just from a management standpoint, there's many, technical steps and legal steps that you have to take, but it really starts with, communication and making sure you are delivering, the message to all of the residents and to the community. What is the problem? How was the problem, addressed? How was it analyzed? What is the plan moving forward? And then a whole review of the financial, picture of the association, and then talking about a special assessment, not just jumping right to a special assessment, right? You want to educate everybody. Alan, do you want to comment a little bit on steps for a special assessment?
Yes, but I would be remiss if I didn't add something about the formulation of your team as you approach repairs. On a major repair project, it may sound self-serving, but actually having a construction lawyer involved as part of the team, many of the general counsel are really not set up to advise on a major repair project. And our firm is targeted specifically towards that. And in fact, a lot of the general counsel refer that work to us because they don't want to be in a position of having to negotiate a major repair contract. But let me just deal with the issue of finances. I ran into a group years ago that had an engineering report that said on all of their buildings, the roofs needed to be replaced. There was active water intrusion in several of the buildings. And the board came up with a 5-year plan for re-roofing, where they were going to do a fifth of the roofs the first year and until the project was completed in 5 years. Because they said, we can't possibly assess our owners to do the entire, all the roofs. They didn't have reserves that were sufficient. And what I advised that group was that, well, first of all, who are you going to choose to be the people who get re-roofed in the 5th year? And just make sure that all the board members' buildings are not in the group that's being re-roofed the first year, because that could look a little suspicious. But the more important point was, you actually, that's not a prudent approach. If an engineer is telling you that all the roofs need to be replaced, you actually have to take action to replace all the roofs within a reasonable period of time, and waiting until that 5th year is not going to be reasonable. So that then you get down to financing. Special assessment is one way. Going to one of our great lending institutions that have figured out that community associations who have low default rates on their assessments are very good risks for loan purposes. So you go in, you get a project loan, or you get a line of credit that will cover the cost of the major repair effort. And then the owners during the progress of the loan are paying some interest carry, maybe some principal repayment, but it's not that major assessment. The problem that occurs, and the engineers are finding this all the time, what do you do when you have a building that's now 40, 50 years old? It's been wood construction, it's on the beach, there's the wood is rotted, there's mold, and the cost of that repair is going to be enormous per unit. You're obligated to do it. I think we're going to find that some condo associations are going to look at terminating the condo as a real possibility. But it doesn't matter that because of bad financial practices that an association has gotten itself into a situation where it's got to do a major assessment or borrow a lot of money to do repairs. It's not an excuse under the statute when you're talking about the repair obligation to say, we don't have the money to do this project. That is not an excuse. It's not covered by the board business judgment rule. It's really a mandatory obligation to do the repair if it's called for within a reasonable period of time, and raise the money from all these alternative means to do it.
Well, and Fiona, if I can chime in real quick,
Yeah.
and be careful. I know some associations that instantly jump into, I'll use Alan's roof example, and they hear from a roofer that's going to cost $1 million, and they take out a special assessment for $1 million. What they failed to understand is that when you start peeling back some of the envelope part of the building, the roof, the stucco, you're going to encounter other items. There's going to be the mold. There's going to be, rotted wood, rusted rebar, things like that. And those all become change orders. So hence the kind of the engineering mindset of, doing some destructive testing up front, developing the proper repair protocols can help mitigate some of those change orders. I'm not going to say eliminate, because anytime you peel back something in a construction project, there's always going to be an unforeseen area, an issue, something that comes up that needs to be fixed. So, kind of Alan brought up a great term, the line of credit. A lot of associations I've seen be successful is they take out a line of credit until it gets closer to near the end of the project, when the likelihood of another change order is small. They have a much more refined cost assessment, and then they can roll that into a loan of some kind for payback with a special assessment. So there are a lot of creative ways. And again, talking to your experts, your lenders, your attorneys, your management company that have those relationships, your CPA, your auditor, they have a lot of those relationships to help you get through these major projects. And as these buildings get older, depending on how they've been maintained for the number of years, say 40 years, if there's been a lot of deferred maintenance, as we said earlier, concrete doesn't heal with time, or rebar does not heal with time. So if there's been improper maintenance, those items are just going to get worse, and delaying any of that is not the right course of action.
Great. And I think to put kind of put a nice bow on this one, we had a couple of questions that came in, so I'm going to kind of meld them together. They're all really around, you know, what if we don't get the vote that's required either to maybe do an improvement or a repair, or do a special assessment or get a loan? You know, what can we do as an association? So from a management standpoint, whenever we're going out to the community to get a vote, you know, we put a whole protocol together as far as, you know, educating the community, doing e-blasts, reminding them, you know, having live events where they can come in and ask questions. All of those things, doing town halls helps secure the vote. And then when you have your meeting, you know, if you don't have enough votes, you can extend out in most cases the meeting. But Alan, do you want to kind of add to that? Because we've got a couple of questions regarding, you know, I can't get the vote, or I can't get participation from residents.
Well, you know, unless you're dealing with a very unusual set of condominium documents or CCRs, usually the owners don't vote on a special assessment. Special assessment is passed by the board of directors. Owners certainly have a voice in it, but it's not something that's subject to a vote. The things that are subject to a vote would be like a material alteration. That requires a vote of the owners. But for the most part, if there are repairs that are necessary, it's the board that has some choices. The board can either insert, if not sufficient reserves, they could either insert the cost of repair into the regular budget for the next year. They can amend the budget in mid-year. They would have to hold a budget meeting, or they could do a special assessment. The owner's rights to affect the budget really come in, and that they do have the right to challenge the budget with a requisite vote of the owners in a condo, and they can adopt their own budget. But I would take the position that because it's a statutory obligation to repair, that there should be nothing that the condominium owners can do to stop the board from moving forward with a repair obligation, because their obligation is to all the owners. You know, to use an extreme example, if you know, if units are getting wet or having sewage backups, the other owners can't say, well, you know, it only affects 3 units, so we don't really want to pass an assessment to take care of that. You know, that's not going to pass muster. So I think folks think that there are impediments to moving forward when they're really not. As long as it's not a material alteration, it shouldn't be an issue. In HOAs, sometimes, again, there's embedded provisions in the documents that limit certain expenditures or expenditures over a certain amount, and they can't get the vote there. That could be an impediment to moving forward, maybe with an improvement, but not a repair. So I think there's some boards who are reading their documents in such a way as to make it more restrictive than it really is in order for them to move forward.
Okay, great. And then Joe, we have a question that's come in, and it says our HOA maintains the streets and stormwater drainage system. Unfortunately, they do not take care of them properly. Heavy rains, as in 2017, even before Irma, caused severe flooding on streets and in some homes. This was not a flood, according to FEMA, so who's responsible for the damage? Any thoughts on that one from an insurance standpoint?
So they said the HOA maintains the streets?
Yes, maintains the
So I mean,
streets and stormwater.
the HOA, or in some cases, there's a CDD as well. That's a component of that, depending on how it's set up. But if it's purely the HOA, it's the HOA's responsibility. If it's not a county or a municipality responsibility, because a lot of times with these developments, the developer comes in, they create the CDD so they can get the infrastructure in, and they're maintaining that through, you know, another assessment on the tax bill to fund the development, so the county or the city doesn't have to connect and bring everything there from an infrastructure standpoint. So it would be on them. So the question as to whether or not there's any insurance in place for those, that would have been on part of whenever they turned over from the developer. And if whomever the agent is and the board was at the time, did they know that those were insurable items for the HOA, and did the appraisal pick up an insurance replacement cost value for those items? So that's a big question that they may not even have insurance for, because perhaps they've not contemplated that as being an issue in terms of the damage occurring to those streets. But clearly, yeah, it would be their responsibility if that is the correct context of what we're talking about. But whether or not they have insurance for it is another question, because you'd have to look into the policy, and obviously whatever the appraisal says, if there's anything noted on there. And a lot of times I find appraisers, I mean, for the most part, they do a fairly good job, but in some cases they do miss items that are, insurable value items that are associated with, the HOA or the condo's insurance responsibility. I see that often. So there's a good possibility that if those values weren't conveyed over to the property carrier as something they have to insure, then it's going to be self-insured retention for any damage there.
One of the things that folks should keep in mind, and it's been mentioned a couple of times, is the liability standard of the association for its maintenance and repair responsibility is negligence. It's not strict liability. So if the board did not have any pre-existing knowledge of a specific drainage problem, there was a big storm and a unit got damaged, it doesn't necessarily make the association liable. And what I tell all associations, that if an owner gets damaged from either an HOA from association-owned property problem or from a common element problem, they should make a claim. The individual owner should be told to make a claim against their own carrier. Because a lot of times, the individual carrier for a homeowner or a condo owner will pay a significant part of the interior damage, and it's always important to push it. Now, sometimes boards get themselves in trouble is, they'll start repairing the interior of units utilizing association funds, and they're setting a precedent for the future. So they need to be very careful about that. And you feel for an owner who's been damaged, but it doesn't necessarily make the association responsible, because it's not a strict liability concept that's in play.
Great points.
And back to that example real quick, Fiona, if there's no actual defined peril that has created the damage of the street, obviously, insurance is not going to be a factor for that. But that's just something that, going back to their example that they mentioned, it didn't sound like there was an actual peril there that would have created that damage.
Joe, can you speak to loss assessment coverage? Because
Sure.
I think a lot of condo owners and even lot owners are not familiar with that type of coverage and what it could mean if in fact there's an underinsurance situation.
Sure, yeah. So loss assessment coverage in the context of an individual, whether it's an HO6 policy for a condo unit or for a single family home, is really designed to help with a special assessment related to under-deductible costs or property damage associated with a insurable event like a storm. We saw a lot of this after Hurricane Irma. One thing to keep in mind is that if your policy, your personal policy, does not include wind coverage, you do not have loss assessment, and you are not eligible for loss assessment. So a lot of the carriers in the personal lines world in Florida are admitted companies, many of which are not rated, but they're admitted, and they have at a minimum, I believe it's 2,000 loss assessment coverage in the statute, and that's going to help offset any type of assessment that would come after a big event where you had maybe a large deductible for in the context of a condo association. Say you have a large tower with a very high insurable value, they may have a 2, 3, or 5% deductible, which could be millions of dollars. And let's say that the damage associated with the storm, they had to pay out $500,000, $800,000. Well, they could assess for that, and that's where you would file your loss assessment claim on your personal insurance to kind of be made whole to some extent, depending on the limit that you have. Now, there are some personal lines carriers that provide up to like $50,000 in loss assessment coverage. However, those companies are, like Chubb, Pure, AIG, Cincinnati. They have a very strict underwriting guideline and appetite, so they're not going to write your standard middle market condo that's, 1,500 square feet. They're going to be doing a lot of the larger sort of higher end type properties. So those options exist, but to Alan's point, it is a very good coverage, and you really need to be educated about it, especially, your homeowners and your condo associations, especially. I have a few clients that, they've done so well on the education that they have, everybody has a very high limit of loss assessment coverage, and they're effectively, in a way, funding their deductible through loss assessment coverage of their individual unit owners. So it's very interesting. And a lot of people kind of forgot about it, and it was dormant until Irma struck, and everybody got reminded in a really big way.
Yeah, I think one message for the boards, and I think that boards can actually take the initiative in educating their owners as to the range of coverage that the individual owners should have. And it actually benefits the association, because you could be in a situation where, rather than chasing, 10 owners for a special assessment to cover a deductible, they're covered for that. And it makes actually the association's job of getting that special assessment funded a lot easier. So I'm a big proponent of boards actually educating their owners on the type of coverage that each of the individual owners should have.
That's a great point. That's a great point, Alan. We got a couple of questions that came in, and I'm just keeping an eye on the time, trying to get to everybody's questions. Brian, we have one that's really specific, and I'm just going to kind of summarize it for you. It sounds like they're in an HOA, and they say we've seen 7 low-lying common area sidewalks that accumulate slimy standing water and obviously represents a hazard. The county engineer says the drains are not cleaned. Another engineer says it's a lack of pressure washing. And a third says these areas should be raised. So their question is, 1, how do we know what to believe? And 2, in your opinion, is there a problem that's is there something that causes this generally, or?
So obviously not seeing the site, this is going to be kind of pure speculation. Some of the common issues that have caused some, I'll call it standing water on a sidewalk, will be tree roots that have caused sidewalks to lift, then thus causing a valley to form, which if the water is standing there with nowhere to go, it becomes that kind of slimy mess with grass clippings, things like that. To know if the drainage system is working properly, we would have to monitor after one of our major rainstorms, how fast does the water come off the streets, come off of the property? Does it stand by the drainage structure for a long period of time? And the drainage structure, I'll back up, are the grates that are in the street or at the curb. You may have what's called a valley gutter, which is a little V. You may have a D curb, which kind of makes the water flow around into a swale, and then it gets collected. So there's a lot of different factors that could cause that water to stand there. But again, if there is standing water for longer than a 24 to 48 hour period, then you may have an underlying issue that could be a number of different reasons why. Pressure cleaning is not going to stop all slime being formed if water is standing there. It is a way to remove said slime, but again, there could be an underlying issue which is causing the water to stand in that certain location and not properly drained. Could also be, depending on the amount of sod that people have replaced in and around, if the sidewalk's going through and you have sod on both sides, you basically created a dam that is not allowing the water to percolate properly through the soil. So there's a lot of different areas that we could take a look at if it's one area or systemic throughout the entire community.
Yeah, and let me pipe in that the question about having 3 different engineering opinions. There's one simple answer. Call Brian. He's better than the 3 that you've had. So that's
Clearly.
Perfect.
Let me just pop in a quick point on that real quick, Fiona. So relative to the sliminess and the slip and fall hazard that could be associated with that, it may seem somewhat benign, but it's not. I have a client that had a very similar situation near their pool area. It was a drainage issue, created sort of a slimy area that some folks had actually fallen a couple times and it brought to the attention of the board. This board was not very astute, to say the least. They didn't do anything about it. It was on the record. As you can imagine, another person fell. That person tragically became a quadriplegic. It became a massive claim for the association. It was a 2-year claim that resulted in a $12.5 million settlement. So these things, as seemingly innocuous as they may be, are major hazards and major liabilities for the association. I will note as well, the umbrella carrier tried to deny the claim based off the fact that the sliminess could have potentially been mold. So they were pointing to their mold exclusion in the policy. So can you imagine the board having been on the hook for $10 million, all because of a small area that the drainage was backed up and they didn't do anything about it? So these things do happen. That's why it's important to, when you do get the professionals involved, you grab the bull by the horns and take care of it.
So, Joey, that's a great point. I just want to, don't take claims from residents lightly. Have your management company go out and inspect. If somebody says that, there's standing water in certain areas, for example, on the roadway, and that could be because, a root intrusion caused lifting of the curbing or anything else. There could be systemic issues that are happening underground, which means the water's washing out of your subbase. You could have a potential sinkhole. Florida's known for sinkholes as well. So don't take those matters lightly, because it could be something greater is happening again beneath the surface. Similar, if you're going vertical in a building and you can't necessarily see the water intrusion behind the building envelope. Same thing for a horizontal community in an HOA. There could be some systemic issues happening underneath the asphalt that you may not be aware of.
Yeah, and Joe, I defended a homeowners association in a drowning case. A child had gone out into the common retention pond, drowned. They had no insurance. And fortunately, I was able to get the association out on a summary judgment on the basis of what obligation a property owner has for a littoral shelf that drops. There's specific law in Florida, but if we would not have won that summary judgment, the association would have been hit with the entire death claim, and they had no insurance.
Wow.
Not a good idea.
No, not at all.
So I'm going to jump back to another kind of grouping the questions together, and it's actually one of the ones that we have up on our screen. I'm seeing quite a few that are coming in, and it's really talking about, when do you have an engineer come in to help you plan your projects, and which projects? How do you determine which ones are most important? Brian, do you want to start us off?
Sure, always. No, it's always call us. No, it is true that if it is a major project, to have a third party expert come in and really analyze the cause of an issue. Otherwise, you have a lot of people's opinions looking at the possible systemic problem. So what we like to do in our kind of course of action is, we do an initial kind of site investigation to see what the true scope of work could be. We do our full investigation, which could mean some destructive testing. For example, we've talked a lot about roofs and water intrusion. Destructive testing sounds a little worse than it is, but it is peeling back an area of stucco to see what's happening behind the scenes, what you can't see, and then putting it back. Developing the proper repair protocol versus bringing out 3 different contractors all providing apples and oranges to how something should be fixed. You should rely on an engineer to develop that proper repair protocol that all contractors are going to follow. Then when they go out to bid, they're all comparing and asking questions on the same repair protocol, the same type of material, the same waterproofing system, things like that. And then having actually the engineer monitor how that construction is progressing. Are they installing it the way that the engineer planned? Are they using the right materials? Are they staying on track? So, having an engineer or an owner's rep during the process is critical on a larger project. If it's a simple repair, that's maybe you don't need that. But we have noticed that a simple repair has turned into something bigger when the full investigation happens. You know, we've been inside an individual's unit that noticed a small crack. We peeled back the sliding glass door. We noticed that there was some problems with the rebar. There was some exposed concrete, and that got fixed. However, what happened was we were also able to then say, you know what, we should probably let's do a random sampling of other balconies. And we noticed that that problem was a systemic problem throughout the building. And so it's always good to bring somebody out. And if it was just a handyman that came and made that fix, you would not have known that there's a systemic problem. So I would say, you know, when you see something like that, when you see something, call an engineer and have them come out and analyze. And hopefully, you know, it's nothing major, but it will definitely help put a proper procedure in place to move forward.
Let me back Brian up on a couple of those points, because I've been involved a lot in repair projects that didn't go well and getting called out to try to mitigate the claim with the contractor. I'm a real big proponent on proper investigation being the first key step. I have seen so many projects that have gone wrong because the proper amount of investigation hadn't been done. You have water coming through a window, and the immediate reaction is, well, you know, we got a window problem. Well, maybe. I've seen situations where there's water coming down from the roof, and it just happens to find a path of least resistance and comes through the windows.
Mm-hmm.
Or maybe it's a stucco problem, and the water's getting it through the wall, but it's eventually making its way through the window. Maybe the window was initially installed in an opening that was too large, and there's a lot of wood bucks around the window frame, and they've rotted out, so that caulking the window is not going to do anything at this point. Maybe it's a manufacturing defect within the window system. There's potentially 5 different causes for that leak actually showing up, and I've seen groups time after time jump into a repair without, I give education on this, and the analogy I use is you go to the doctor and you say, I'm having abdominal pain, and the doctor says, well, show up at the hospital tomorrow, we'll open you up and we'll take a look and we'll try things. And you say, you get out of that doctor. But
go see a specialist. You go see the specialist.
So many groups jump into a repair before they actually know what the problem is, and change orders are so costly under those circumstances, and then the potential of claims are enormous. So spend the money on a good engineering firm like Brian to really dig into the building and find out, because all you're seeing is the end result of an issue. What's causing it can be really complex, could be a combination of factors. And then that's your only opportunity to have the specifications actually be on point. If you actually know, again, using a medical analogy, it's like getting a prescription ordered by a doctor who doesn't actually understand what's wrong with you. That's not going to work out very well.
Actually, Alan's a great point, because we've actually been brought in when the board thought they knew better, ordered brand new windows for the entire building, updated. However, the scope of work wasn't accurate. They installed the wrong type of window, and they were not installed correctly. And so there was all these water leaks because they didn't allow the water to drain properly off of the window, and all the weep holes in the windows were caulked over and basically caused all the water to go inside each individual unit. So there's so many different things from not just the engineering report up front, but it's even during and through construction, and actually using Alan and his firm to make sure that the contract with the contractor has liquidated damages and timeframes and all those things, and how punch lists are going to be done throughout the course of the project. One of the things that we're a big proponent of is we go and monitor the construction throughout the course, so that if we notice something during the week, we can report back to management, the board, and the contractor and say, you should fix these 5 items, versus having 900-point checklist at the end of the project, you have 5 right up front that they can fix within the week because they're already in the same stack, things like that. So it's all about having your partners and your advocates for the association that fight for the same cause, and you get a much better product at the end. Like I said earlier, doing it wrong costs you so much more than doing it right the first time.
And we feel for the boards, because the owners who come to the meetings are the ones who in unison all say, you must keep our assessments down. And that ends up being the most vocal people that you hear from. The fiduciary obligation to maintain and repair, though, is on the board.
Mm-hmm.
So you need to tell those owners that, look, I have the fiduciary obligation. I'm going to get an engineer to do a proper investigation. I'm going to get an engineer to do an appropriate set of plans and specifications. I'm going to opt for contract administration. I'm going to get a construction lawyer to review the documents. I'm going to see somebody like Joe to make sure that our insurance is in place in an adequate amounts to cover the perils. And if the owners don't like it, then you should get new directors. But what I've seen so many boards do over the years is they defer to the folks who just don't want to spend any money, and they end up getting themselves in a lot of trouble as a result.
Definitely.
One of the questions we did have come in, Joe, is for you, and it's asking, what do you recommend for minimum insurance coverage types and amounts? I know that's a little broad, but maybe you could speak a little bit in general to
So,
that.
yeah, no, that's a good question. Hopefully, the property manager or property management companies are at a minimum getting the certificates of insurance from these vendors that they're going to do business with. That's extremely important. But one thing to note on the certificate of insurance is that it's really nothing more than a piece of paper that just came from an agent somewhere showing limits of insurance for their client. So it's not coming directly from the carrier. So you really can't put too much weight into that. You got to do a little bit more research. And one thing that we always advocate for is having sort of a supplemental or an adjunct agreement, something you would call an independent contractor agreement, that you can get, a lot of the HOA and condo attorneys have these. Some agents use them, we do, and it basically provides limits of insurance that are kind of minimum standard level for contractors to actually come on site and do business with the association. And some of those things you're going to want to look for and recommend is going to be general liability. 2 million general aggregate is a pretty general standard. You're going to want to make sure these companies have an umbrella in place. You're going to want to make sure their bodily injury on their auto, because they're going to be driving on site, is at least 1 million, things like that. But more importantly, you want to make sure the association is named as an additional insured. That's really critically important, because you want to get the power of the vendor's insurance in the event of a claim, property damage, bodily injury, whatever occurs, products, completed operations claim, because you're going to get named. The association is going to get named. There's no question about it. You want to be able to tender that over to the insurance of the vendor. And the one thing to note is that additional insured, you're not going to get it unless it's required by contract. So many associations get this certificate and it just says, oh, we're named as an additional insured. That's fantastic. Well, actually it's not, because it's not a contract requiring you, the carrier, to provide that for you. So a lot of boards need to know, they really need to dive into the insurance requirements, a lot more than they do. And in the context of like a condo, if there's somebody doing a higher hazard sort of internal unit renovation, like a gut renovation, you can take those same requirements and you can sort of retrofit those into the architectural review committee process. That way you're not approving, who knows what type of insurance for whatever GC is coming into the building that could hit a sprinkler head and cause hundreds of thousands of dollars in damage to other units. So you can use those same requirements to make sure that the association is protected on all fronts, in the building envelope, but also interior as well. So it's a really critical thing. It's very important for associations, for managers to be on the lookout for, and recruit your agent to take a look at it as well, because there are some special types of insurance that different vendors have that you may not see on the certificate of insurance. You want to make sure that they have whatever those specialty insurances are, depending on what type of contractor they might be, whether it's pollution or environmental impairment or pesticide, herbicide, or whatever. And you might not be able to see that they have that. So really think through what the exposures are and whether or not these folks that are coming on site, yeah, they might be cheap. That's great. But the cheapest is not the best. We all know that. If they're skipping on their insurance, they're one claim away from just disappearing and you having to chase them civilly for the rest of your life. So be very careful what you deal with on the insurance requirements.
All right, a couple more tips. There are actually general commercial liability policies for contractors that exclude homeowner and condo associations from coverage. So be very aware of that. Another thing is that when, for instance, when you talk about professional liability coverage for your engineer, I was reviewing a contract for a sinkhole repair the other day under 12 buildings. The engineer had $500,000 limit on their professional liability coverage. And for a $7,500 project premium, we were able to raise the engineer's liability coverage to $5 million for the project. So there is the possibility, especially with professional liability insurance, to get a project-specific increase in the engineer's coverage when you're talking about either a very large project or a very risky project, with the association being a named insured, which is very significant. And so just be aware of that there is a possibility of getting project-specific coverage of a greater amount than at least an engineer. I don't know in the TCL policy whether that's possible, but I've always been told, and Joe could probably back me up, that for the right price, you could really cover anything or increase coverage for anything. There's always a market for it.
Yeah, I mean, generally you're right, Alan. I mean, there's a lot of project-specific policies that contractors can do, and they can also endorse the existing policy to meet any limits that they might be able to have for that project. But to your point, and Alan made a really good point, a lot of these contractors, multifamily work is like radioactive in the insurance industry. So a lot of contractors that are doing it, there's so few insurance carriers now that want anything to do with the multifamily work. So if they're dealing with a condo association or anything related to where it would be like a construction defect or something like that, you want to make sure that you get the forms list of their general liability policy to make sure that they don't have an exclusion for any type of work that they're doing in the context of a condo association, because my God, that's great that you get additional insured, but they don't even have insurance to cover it. And you wouldn't know that unless you actually saw the policy or you had your agent assisting you with that, because they know what they're looking for. So, the certificate of insurance is just the tip of the iceberg. There's a heck of a lot more to it that you really need to be aware of.
Great. Well, we are just about out of time, but Alan, I did want to read to you this last question, and we're going to connect you with this person. But they're looking for advice for an HOA that is embroiled in pending or ongoing litigation and arbitration with the builder whose construction practices are showing shoddy work, and our engineers continue to expose issues.
So they already have a lawyer, or they need a lawyer?
I think it sounds to me like they may need a lawyer. So
okay.
I'm not.
Thank you.
Yes, I think that's the answer to the question. Is we are going to connect you guys, and we'll go from there. So with that, everybody, I can't believe it. An hour went by super quick. Gentlemen, thank you so much for your time and your experience and sharing that with everybody today. And for everybody who joined us, thank you so much for being here and spending some time with us. Our team will be following up with you. You'll be able to review this at castlegroup.com/webinars. It'll be posted in the next couple of days if you wanted to re-listen to get any more detailed information on the answers. Brian, Joe, Alan, thank you so much. Really appreciate your guys' time today.
Thank you.
Thank you, Fiona. Thank you, everybody.
Take care.
Stay safe.